Our South African Police Service is conducting an internal investigation about the leaking of personal details of sexual assault victims linked to the alleged Krugersdorp gang rape case. Now, this comes after the Information Regulator found that the police violated the Protection of Personal Information Act by distributing the names, identity numbers and addresses of the victims. 8 women were allegedly robbed and raped by armed men believed to be Zama Zamas while shooting a music video and at an abandoned mine dump in West Village in July 2022. Now, for more on this matter, we will be joined shortly by the Information Regulator's chairperson, Advocate Pansy Tlakula. But before we do that and get into the interview, this is what the National Police spokesperson, Brigadier Atlenda Mate, had to say on the matter.
The SAPS has noted the ruling of the Information Regulator regarding the unauthorized disclosure of personal information belonging to victims of crime. The SAPS will abide by the ruling and ensure compliance, notwithstanding the outcome of the internal investigation into the said disclosure, which will be made public within the stipulated period.
And we're joined now by the chairperson of the Independent Information Regulator, I should say, Advocate Pansy Tlakula. Thanks so much for your time and welcome to Morning Live.
Thank you very much and good morning to you and your viewers and happy Easter to everyone.
And to you, Advocate Tlakula. So this is a very important case because I think very often when we talk about the Protection of Personal Information Act, we talk about it in very abstract terms without necessarily seeing how practically that would play out. And this is a key example of this, especially in a matter involving criminality. But what prompted the Information Regulator to investigate the police's conduct in this particular matter?
Okay, what happened is that we picked up the message on WhatsApp because you'd recall that that message went viral. So we decided to conduct our own investigation on our own initiative because the Act allows us to conduct an own initiative investigation. We thought that this was a very serious matter because the disclosure or publication of the personal information of the victims of sexual assault amounted to secondary trauma. So we thought it was appropriate for us to investigate the matter.
So, Advocate Tlakula, the Information Regulator also says that the South African Police Service failed to provide sufficient detail regarding the circumstances that led to the disclosure of that personal information of the 8 women. What has been their response initially?
When they came to the Information Regulator to make their submission, they did acknowledge the fact that the manner in which they handled the personal information was in contravention of the Act and that they did so unintentionally. They also acknowledged the fact that maybe people are in the SAPS are not aware of how the Protection of Personal Information Act works. So they made some concessions, but at the beginning, they tried to say that the processing of personal information of these victims was excluded from the Act because in terms of our Act, certain processing is excluded. For instance, if you process personal information in the course of investigating a crime, then the Act does not apply. But if you look at the manner in which this personal information was shared, it was not shared only among the police who were investigating the matter. It was also shared among administrative staff and also some cleaners in the police station, and it was shared with police around the West Rand area. So we could not sustain their argument that they shared that personal information in the course of investigating the crime.
And I suppose worse, which is not necessarily your beat, Advocate Tlakula, but the fact that there was someone felt the need to share that information because I know in trying to follow up on that story, for example, when we spoke to a relative of one of the victims, that secondary trauma that you talk about was very real in that people had been identified and some of them really, really struggled with that given what had happened to them.
Not only identified, their residential addresses were also in that WhatsApp message. So this is quite a serious matter. It's a serious violation of the Act because the police processed that personal information unlawfully and unreasonably. They did that without the consent of the victims. They then went ahead to further process that personal information by sharing it. That's why it went viral. Or this also points to the fact that they don't have technical and organizational measures in place to secure the personal information that they collect. And when this thing happened, they were supposed to inform us because the Act says once there is a security compromise of personal information, then the information regulator has to be informed, the victims too, or the data subjects have to be informed. So when we analyzed their conduct, we came to the conclusion that several provisions of the Act were violated. And the unlawfulness is quite serious because if you're a police, we don't expect, law enforcement agencies to process personal information unlawfully.
And as the information regulator, was there any punitive sanction imposed on the South African Police Service as a result of this, Advocate Tlakula?
This will come later because at the moment we have given them timeframes within which to implement our recommendation, including investigating the matter, including publicizing, I'm sorry, publishing, that's the correct word, publishing an apology in major newspapers and in social media platforms. If they don't comply with those recommendations, then they will be committing an offense because that's what the Act says. And once they've committed the offense, we can then issue what is called an infringement notice that can lead to criminal prosecution or payment of a fine. But there is also another remedy that is available to the victims. Or they can, on themselves or by themselves, institute a civil claim for damages against the SAPS, or they can request the Information Regulator to do so on their behalf. But that is a remedy that is available to them. As far as we are concerned, we have issued the recommendations and we will be monitoring the implementation thereof so that we can take corrective action if those recommendations are not implemented.
So what this highlights, of course, as well, Advocate Tlakula, is the need for training, not just in the SAPS, one would imagine, but much more broader, especially for people who happen to deal with cases like these in one way or another. You take, for example, our space as broadcasters, how we deal with such information. Do you feel that this is taken seriously enough and that there is sufficient training for practitioners on the ground around this matter?
Yes, indeed. One of the recommendations that we made was for training of the police, but you are absolutely correct that this is a new piece of legislation and there is a need for widespread training and public awareness on how the Act applies across the board. I can even tell you that even the SABC, we have an investigation that we are conducting against because there was a breach of personal information of data subjects. So the non-compliance with the Act is still widespread, but we are mindful of the fact that this is a new piece of legislation and people have to be trained so that they can know how to handle personal information in their possession.
So just as a parting shot for us, Advocate Tlakula, for ordinary South Africans watching this program now, what would you say to them, just as a general guide of how to deal with people's personal information, how this would affect not only businesses and institutions, but ordinary people as well?
So the ordinary people, particularly the people who are active on the social media space, they have to be careful about what they put on social media, because once you put your personal information out there and you do that intentionally, then you lose control. You lose a protection of the act. So I just see that young people in particular, they put a lot of personal information of theirs on social media platforms. And in this digital age in which we are all living, that exposes them to all sorts of criminal activity, including being hacked, including their bank accounts being hacked and so on, and exposing themselves also to cyberbullying. So this is a very serious thing of putting personal information, and that also people must look at what their children are doing online, because most young parents, they let the computer babysit their children. Children are always busy online and sometimes without being supervised. So we need to change those habits because they can lead to all sorts of problems.
Well, we're going to leave it there. Advocate Tlakula, I don't want you to be late for church on my account. So thank you so much for your time this morning. Information Regulator Chairperson Advocate Pansy Tlakula speaking to us about the South African Police Service being found guilty of violating provisions of the POPIA Act by distributing the personal details of the victims of that Krugersdorp rape ordeal.